Okay, class, this is Wednesday, October 7th. I had to record a bunch of these in a row, so sometimes I'm wearing the same outfit because I did multiple days. Because as you're watching this, I am in Nashville, I think. Maybe I'm on my way home. So let's recap what we taught yesterday. Remember, you're going to have a review guide this week, Thursday, on all of the amendments. So you've got to take good notes. You've got to take the notes that I'm showing you on the smartboard, and I'm explaining them just so you have an understanding of them. But not only is it going to be this one worksheet, then it's going to be probably another worksheet that we'll review it again, and then of course it's going to be on the test, and then all of this is fair game on the air. So you want to make sure you know all of this material, and get it written down in your notes. It should make everything a lot easier. So let's share screen and pick up where we left off with these notes and see if we can give you some more examples. This Constitution stuff, like I keep saying, there's nothing more relevant that I teach than the Constitution, because these are your rights, our rights, and how they get applied and how they are in real life is very important. So First Amendment, freedom of religion, speech, press, and assembly, and to redress grievances. That's all in the First Amendment. We covered that a couple days ago. Right to bear arms. How far does your right to own a gun go? But generally speaking, Americans have a right to own a gun. No forced quartering of troops. Third Amendment, you cannot be forced to house federal soldiers or state soldiers. Search and seizure, you must have reasonable cause and specific details for a warrant. There are a few exceptions. So on the worksheet, on the test, I'm going to have examples that cover all the amendments, but I might say, okay, a community passes a law that says if you have kids under 18 in your house, you must have a gun safe if you own a gun. You don't have to come up with how the Supreme Court would decide in that case, but what I would say is, which amendment will they be arguing about? It'll be the Second Amendment. I put a big bumper sticker on my car for a presidential candidate, and my boss tells me you can't park that car in this parking lot or you're fired. I don't know how they might rule on that, but we know what amendment they're going to be discussing. They're going to be discussing my freedom of speech. So it's your First Amendment. There's going to be a lot of questions like that. So it's not just that you have to know the amendments. You've got to be able to apply them. And that's why we're trying to give you as many examples as possible. So our first one, and you just had this intro note yesterday, is rights of the accused. So there's a lot jammed into the Fifth Amendment. We're going to start off with this one. No double jeopardy. That means you cannot be tried for the same crime twice. So this gets misunderstood a lot as well. But if I rob a bank, or I'm accused of robbing a bank, and that's my go-to crime that I use for these examples, and I'm found not guilty of robbing the bank, if they find new evidence after the trial, they can't come back and get me again. There's no such thing as, there's no double jeopardy. I cannot be tried guilty for that crime. Now, that's to go to jail. Now, some of you who might be familiar with one of the most famous court cases ever, the O.J. Simpson trial, you know that O.J. Simpson was found not guilty of murdering his ex-wife and the gentleman that she was with, and yet he lost millions of dollars in a lawsuit, because that's in civil court. In civil court, there's a different standard. In criminal court, to convict somebody, you're supposed to be like 95 to 99% sure they did it. And there were a lot of reasons why the jury was not 95 to 99% sure that O.J. Simpson was guilty, so he was found not guilty. But then he was sued for money. He couldn't have gone to jail in the lawsuit. The lawsuit was for money, and that's a 51% threshold. If the jury, not you or I, but if the jury is like pretty sure he did it or responsible, then they lose money. So that's how you could go, well, what happened to OJ? And then he ended up going to jail later, but that was for holding somebody at gunpoint to steal some of the stuff they had to sell because he lost the lawsuit. Different thing. There was a really bad movie maybe a dozen years ago about this woman who was accused of killing her husband. It was called Double Jeopardy. A woman who was accused of killing her husband, and then he had faked his own death to escape some financial problems or whatever and frame her. And then she goes to jail, and she comes out, and she knows she didn't kill him. And she starts to think that he's actually alive, and like she finds him. And then she's got him at gunpoint, and he's threatening her, but she's got the gun. And then he says something like, "Oh, you don't want to go back to jail," and she says, "I can't. No double jeopardy," and then she shoots him. Sorry if I just ruined that movie for you. That's complete fiction. That's a different crime. If I'm found not guilty of robbing a bank October 7th, I'm found not guilty. I could still be found guilty of robbing a bank October 8th or October 7th at a different time. It has to be that specific crime. So in that movie, she was found guilty of, in reality, of killing her husband, like say in 1990, and then in 2000, it's a whole different crime. And you could say, oh, well, they shouldn't have thrown her in jail then. She can sue, and that happens every once in a while. You see somebody went to prison for a crime they didn't commit, and they can sue. The whole idea is, if the government just hates somebody, you can't just go after them again and again and again, hoping to get them the next time. You get one shot, one shot. Okay. This one, it just doesn't even seem like it belongs in there. But it does. It's something called eminent domain. It's really a peculiar thing, but it's smart. And it says, if the government really, really wants your land, they can't just have it for any old reason. If it's a really good reason for public good, they can have it. But you must be reimbursed. And so they'll get usually 3 assessments of what your land's worth and then pay you the middle one. Now you go, why would the government want my land? It's happened around here in Sandusky, in the area in general, quite a few times. I'm old enough to remember when 250 was only 1 lane going north, 1 lane going south. When they wanted to widen it because of all the Cedar Point traffic, there were houses that were right there on the edge. So they had to be destroyed or moved. So if you owned one of those houses, the first thing they do is they say, hey, would you like to sell? And a lot of times, especially actually if it's a private business, they'll say, would you sell for this? Why do old people leave their phone on ringer? I'll turn it off. Will you sell for, if your house is worth 100,000, sometimes they'll say, will you take 150? Yeah, that sounds like a pretty good deal. Some people won't sell. Some people will say, no, my grandpa built this house, or I've owned this house since forever and I'm not moving. Think of the movie Up. That guy was never going to move. If that happens, the government has to go to court and prove that it's for a really good cause. So if it's to build a Starbucks, they're not going to win. Even if the city wants the Starbucks to be built, they're not going to win. They're going to go, no, there's another Starbucks around the corner or whatever. But if they say, oh, it's to widen 250, and because we're going to widen 250, we're going to have more traffic coming into Cedar Point, which is going to bring in millions of dollars for that, the hotels and the restaurants, they're going to win. And so if you refuse to sell, they'll file eminent domain on you, and then they'll do some assessments of your house, and then they will pay you a fair rate, but you will have to sell. I think it was done in Sandusky for the hospital. I believe the hospital was expanding, and some people sold right away. And what a hospital will do sometimes, or any business, is they'll say, oh, we want this to go faster, so they'll offer you more money. And some people are like, yep, I'll take it. But some people have, understandably, an emotional attachment, and they're not going to move unless you make them. And that's what happened. You file eminent domain, and they reimburse you for your land, but the government can take your land. So if the city of Norwalk wants to encourage Starbucks to build a place here, and Starbucks tries to buy up 5 houses, if they sell, great. If they refuse, you can't file eminent domain to build another coffee shop. You could do it for a highway, a hospital, something really important for the public good. All right, now here's though where most of you are thinking of the Fifth Amendment. You cannot be forced to be a witness against yourself. You plead the Fifth. You might say to yourself, well, why would I be a witness against myself? That doesn't make any sense. I'm looking for a book here. Okay. I've got my AP history book here. If you imagine, whoa, that was a good catch. If you imagine back in the 1700s in particular, there's a lot of pressure on people who take an oath when testifying in court. And this is actually just an AP history book, but we'll pretend this is a Bible. And if you put your hand on the Bible and you say, I promise to tell the truth, what it essentially does is it puts you at an advantage if you're comfortable with lying, if you're not religious and you don't think that oath means anything to you. So a really religious person might feel like, oh my gosh, I can't lie. I just put my hand on the Bible. Somebody else might feel like, oh, I can just lie. So they said, you can't be forced to be a witness against yourself. Now, usually that is not the only evidence against somebody. But if I'm accused of robbing a bank and they pull me in and they start interviewing me and they start questioning and they say, just admit it. You know, we've all seen the cop shows. Admit it. You robbed that bank. Now, if I just volunteer, yep, I sure did, they can use that against me. But if I say, you know what, I don't want to talk. I don't want to. And even in court, they could say, they put me on the stand and they go, hey, did you rob that bank? And I go, I plead the fifth. Now, do I look guilty? Yeah, I look guilty. But looking guilty is not enough to put you in jail. They better have some footage. They better have the stolen money in my house or something like that. There has to be some evidence against me beyond me just looking guilty because I wouldn't testify. Here's the cool part. This extends to other people in your life. So my Fifth Amendment right can be extended to important relationships in my life. So scenario, I rob a bank. I come home, Mrs. P's like, what's that giant bag? Oh, it's a bag of money that I robbed from Fifth Third. If the police interview her, she goes on, if I am on trial and they say, did he rob the bank? She could say, I plead the fifth, he's my spouse. She does not have to testify. They think it's unfair to put your spouse, your husband or wife, in that position. By the way, she can waive it. She could testify. Maybe she's mad at me and she hid the money. She could say, I don't have to testify, but I will. Yep, he robbed that bank. He robbed $1 million? And she says, $500,000. Mm-hmm. And, whatever. But she doesn't have to. Now, attorney-client privilege. So I just pulled some names, and I'm going to make Marie my lawyer today. Okay, from first period. Marie, I hope I'm saying your name right. She's going to be my lawyer. So we'll flash forward 10 years from now. Better give you 10 years should be enough. Marie, she has her law degree. She's a lawyer. She's all set, and she's my lawyer. And I come in and I go, Marie, I remember I used to be your teacher. Oh my gosh, I'm so glad you're a lawyer. I need a lawyer. And she goes, sure, I'll be your lawyer. And we exchange money. I put down like $100 deposit or something. And I say, oh my gosh, I just robbed a bank. She goes, oh my gosh, Mr. Penrose, I can't believe you robbed a bank. And I go, oh, I know, it's crazy. She can't testify against me. She's actually not allowed. She can't waive it. I could waive it. It's a long story why I would, but basically, she cannot waive that. So they cannot put her on the stand. And they say, Maria, we'd like you to go on the stand. Did he tell you he robbed the bank? Nope. She cannot testify against me. Otherwise, how would you ever have any faith to tell your lawyer anything? So that's attorney-client privilege. She cannot testify against me. Now, keep Maria in mind. We're going to give you an example where she has to, but it's a rare exception, okay? And then doctor-patient privilege. So I'm going to make Aiden from fourth period. He's going to be my therapist, okay? I go to Aiden and I say, I got a real problem. I really love robbing banks. It's really causing a lot of angst in my life. And I go to him and he says, oh, you should turn yourself in. And I go, no, I don't want to turn myself in. He cannot then call the cops and go, hey, this crazy guy just robbed like 5 banks. And he told me he robbed 5 banks. So you got to arrest him. Nope, he can't testify against me. Fifth Amendment, my Fifth Amendment protects me from my doctor, my lawyer, or my spouse from testifying against me. Notice some relationships that are not there. Those are the only ones. Oh no. Alarm. Sorry. Those are the only relationships there. My kids, if my kid's moving to Nashville, Tennessee, he commits a crime there, tells me about it, I get put on the stand, I have to testify against him. Now, if I don't, I can be ruled in contempt of the court and I can go to jail. And that happens sometimes with parents and kids. And reverse, if I rob a bank and my kid knew about it, he goes, I can't testify against my dad, then he's going to go to jail for contempt of court. There's no best friend exception. And that's tough. There's no brother-sister, brother-brother, or sister-sister exception. Your siblings. In the eyes of the law, you have to give up the information you have about them, that's tough. That's real tough. And a lot of times, people just go, no, I won't. And so they go to jail. Let me give you the exception, though, for my spouse, for my attorney, Marie, and my therapist, Aiden. Future crimes. For future crimes, they have to turn me in. In other words, when I go to my spouse and I say, oh my gosh, here's this money I just robbed from the bank. She doesn't have to tell on me. But if I say, hey, honey, I'll be late for dinner tonight. I'm about to go rob a bank. She now has to turn me in because I'm telling her about a future crime, or she's now an accomplice to the crime. Let's go to Maria. Maria is my lawyer. She's established as my lawyer. She's a good lawyer. So she gets me out of that first bank robbery. And then I stop by her law offices on Friday. I'm like, hey, Maria, what's going on? You busy this weekend? She says, no, I'm just sticking around this weekend. Why? What's going on? And I go, oh, I'm going to be robbing a bank Saturday morning. If things go south, I just want to make sure you're here to, take care of things. No, that's not how that works. Now, Maria has to call the cops and say, this guy just told me he's going to rob the bank tomorrow. Has to do that. Otherwise, she is a part of the crime. So that's that exception. If I've already robbed the bank, she can't turn me in. If I haven't yet, and I just told her, hey, be ready, stick around, no way. Same thing with Aiden. I tell Aiden as my therapist, man, I love robbing banks. It's so great. He's like, yeah, you should turn yourself in. And I go, no, I'm not turning myself in. As a matter of fact, Doc, I'm going to rob 3 banks on Monday. Are you around Monday night? Because, man, I'd love to talk to you about it. He's got to turn me in, or he's now an accomplice to this crime. All right, that is the Fifth. Now, again, there's whole law classes taught over the Fifth Amendment, but that gives you the basic ideas. You'll have to know the term double jeopardy, eminent domain. You'll have to know what the Fifth does in general and know these relationships, okay? Sixth Amendment, right to a fair and speedy trial, okay? Listen, this one gets sort of overplayed and underplayed sometimes. Speedy does not mean fast. Our court system is clogged up. So there's times where you get arrested for a crime and your trial doesn't happen for 6 or 8 months later. If that's the first court opening date, that's fine. What they can't do is have a date available for your court case in a month and they go, we don't like you. We're gonna make it 8 months. It has to be the first, open date. And to a fair trial. So that means, and that's been described in several court cases, fair trial means, for example, you have the right to an attorney. There's a very famous court case you're going to learn about months from now called Miranda versus Arizona. Should sound a little familiar. It says that you have a Miranda right. You have the right to an attorney even if you cannot afford one. And so if you've ever seen a cop show, you know you have the right to remain silent. That's your Fifth Amendment. Anything you say can and will be used against you in a court of law. Like an attorney, you can have an attorney. If you cannot afford an attorney, one will be appointed for you. So they read through that. What is really done poorly in movies, and the one that makes me laugh just thinking about it, is how poorly the law is Tyler Perry misled you when I believe Madea gets arrested. I forget which one, and they forget to read her rights, so she's free. Yeah, that's not how that works. Not how that works at all. It's just bad law. Funny, but bad law. If I'm arrested for robbing a bank, I'm teaching you, we're back to live, we're in person, I'm teaching you, and all of a sudden the cops come in and they arrest me and they're like, we got you, and they put me in the car. And they never read me my rights. And I'm in the car going, yep, I robbed all those banks. Ha, ha, ha. They can't use that against me because they didn't read me my rights. But if they got my fingerprints at the bank, if they got camera footage of a not real tall guy robbing the bank and they found all the money that I robbed, they can still get me. They just can't use what I said against myself because they didn't tell me I had a right to not talk. That's all that means. So you still get to use, again, all the evidence, the purple dye and the, and that explodes all over the cash when you steal it, the money itself, the video footage, the 3 witnesses, all that stuff still gets to be used. They just can't use my own blathering in the back of the cop car unless they have read me my rights and I'm still dumb enough to keep talking. So they say you have the right to remain silent. Anything you say can and will be used against you in a court of law. And I go, oh, okay. Hey, thanks for telling me that, guys. I did rob those banks good, didn't I? Now they can use that testimony against me because I'm so dumb that I just blathered about it afterwards. It also means I get an impartial jury. I've been picked for jury duty 4 times. It's interesting, but sometimes it's a little more boring than you would think. And in jury selection, they have a right to go through and ask you a bunch of questions to make sure you're not going to be predisposed to be biased. It goes back to the same theme. We talk about bias and unbiased all the time. It doesn't matter which way the bias is. If you're biased, they don't want you in the jury. They want somebody who's really neutral. So they could say to you, if I'm accused of robbing banks, none of you could be on there because I was your teacher, but let's say it's some other teachers accused of robbing banks. They might say to you, all right, so there's a teacher in this trial accused of robbing banks. How did you like your teachers? And if somebody says, I hated all my teachers, they're all awful, they're not going to be on the jury because that's biased against all teachers. They're going to assume they're guilty. Somebody else says, oh, I love teachers. I've always wanted to be a teacher. And every teacher I've ever had has been amazing. Well, that person's too biased the other way. What they want is somebody who's like, I've had some good ones, I've had some bad ones, whatever. That's who they want on the jury. Now, sometimes this is tough because the person accused is famous. You know, Michael Jackson had 2 jury trials. And in both times, they had to go through, in one case, I believe 2,000 jurors before they found 2,000 jurors who didn't already think one thing or the other. Because a bunch of people are like, Michael Jackson, he's the greatest ever. He couldn't have done anything wrong. And the other half were like, I've heard all the Michael Jackson stuff. Of course he did it. What you need, and it's hard to find, is the person who goes, Michael who? That's what you got to try to find. And that's really, really hard. For the average person, it's not that tough, but you need to find a jury that hasn't already made the decision. Okay? Impartial jury. And so the lawyers get to ask them a bunch of questions. And I was asked a bunch of questions when I was in that jury trial to see if I had a predisposed feeling one way or the other about the defendant. And I didn't, so I ended up on that jury. Right to an attorney, we talked about that already. And you have the right to see witnesses against you. This one's really pretty clear. If someone says, Mr. Penrose punched me in the head, I'm accusing him of assault, okay? The only way I can defend myself is if I know who accused me of that. Because if you say, oh, it's Mr. Nedgedly, well, then I'll go, oh, Mr. Nedgedly is just saying that because he's mad that I did, you know, we had this argument about this, that, or the other thing. That will be my defense, and the jury will get to decide. If they say, we can't tell you who said you punched him in the head, well, then how am I supposed to defend myself? Now, there are a few exceptions. And some people think there should be more. If a little kid is a victim or a witness to a crime, they usually will not make that young child testify because of how traumatic it would be for that person. Now, listen, adults are traumatized by this too, but they just tell adults, I'm sorry, you're going to have to testify, even though they may have witnessed or experienced something just horrific. Adults have to. Kids, what they usually do is the judge will interview the child with a series of questions from both lawyers in like a different room, and it's videotaped. So maybe the jury gets to see it, but the kid doesn't have to stand or sit there in front of everybody and look at the person who's accused of the crime. For the most part, you do, even if it's like, just a young, like 18 years old, and you witness something horrible and you're really scared. I'm afraid that you got to be up there. Okay, we're going to fly on a couple more of these. Civil suits. This one's really easy. You have the right to a jury trial in all cases where you're suing for money for $20 or more. You can waive it, and you should, because if it's cheap. If I'm suing somebody for $100,000 or I'm being sued for $100,000, I better get a lawyer. There's a lot on the line. But if somebody's suing me for $20, for $50, I'm going to waive my right to an attorney and to a jury trial, because I want to go in front of basically a Judge Judy or a Judge Joe or something like that, where both of us have agreed, listen, lawyers are too much. We're just going to appear and let this judge decide. Now, if I want to be a jerk about it, I can insist on a jury trial. But then there are court costs, and I for sure have to have a lawyer, which is why I would probably waive it for, I don't know what my amount would be, but for sure 500 and under, I would just be like, no, let's just let a judge decide. But I'm entitled to a jury trial. And for sure, if I was suing or being sued for, say, $1,000, I'd probably get a lawyer and make sure, that I was protected. But $20, some roommate from college says you kept a record of mine, it's worth $20. Okay, we'll let the judge decide. I'm not going to hire a lawyer for $500 an hour. Marie, I got to pay Marie now $500 an hour to defend me in a $20 lawsuit. It doesn't make any sense. Eighth Amendment. No cruel or unusual punishment. This is a big one. I won't babble on as long about this one. This is a big one. It's very clear. It's gone back and forth. The Supreme Court has changed its mind on this particular amendment. And they do that sometimes. The Constitution is evolving, it's alive. But the death penalty is a big one that they have on this one. For centuries, I mean, a couple hundred years, death penalty was totally legal. And throughout our country's history, we've executed people in a lot of different ways for mostly murder, treason, and early on in our country's history, sexual assault. And hangings were common. Now, in the more modern times, you see, you know, for a while it was the electric chair, and now you'll see why that's not allowed anymore. And it's in most states. Now it is lethal injection. Eventually, the Supreme Court, I believe in the 70s, said, you know what? Putting someone to death is pretty cruel and unusual. Plus, you're sitting there on death row and you're waiting and you're anxious about it, and you know you're going to die 3 years from now on this particular day. And they decided it was unconstitutional. So that's it. They changed where the nose gets hit, and they said, nope, no death penalty. And then they brought it back. They brought it back and said, no, we decided it is okay, but it can't be done in a mean way. So they decided the electric chair was too much pain, too many things go wrong too often. That's why you have to have lethal injection. So what they do when they kill somebody, execute somebody for murder, is they give them at first the same drug that you or I might take if we were having a surgery. It's the one that just knocks us out. Then they put in the stuff that kills them, and they say, well, that's not cruel because it's just putting them to sleep, and then we kill them. You cannot, according to the Constitution, execute somebody by like chopping them up into little pieces. That's not allowed under the Constitution. No cruel or unusual punishment. It's supposed to be as neutral as it can be, if that makes any sense. So the death penalty, though, that's still, people argue about that all the time. It doesn't matter. It's whatever the Supreme Court says. Right now, the Supreme Court says if it's done in a humane way, lethal injection, then it's allowed. They may change it again. I'm more interested in how this works, kind of smaller cases about this, not death penalty. Very famous case, and I cannot, it's a small state. I can't remember which state it was, but it was about the cruel part, not actual death penalty, but just a different cruel punishment. And it was a high school football player who was speeding. We're not talking about a serious crime. We're talking about speeding. Not great, but not death penalty stuff. And a highway patrolman pulled him over. Well, this highway patrolman also happened to be his football coach. So the highway patrolman doesn't want to give this guy, he's probably got a decent relationship with, a ticket. He wasn't going a crazy amount over the speed limit, but he's his football coach. So he's thinking like a football coach, and he says, all right, I tell you what, do 100 push-ups right here on the side of the road. It's raining in the mud, 100 push-ups right here, and we'll let you off with a warning. So he does his 100 push-ups. That's what I would do if I could do 100 push-ups. And he does his 100 push-ups, and he goes home. He feels pretty lucky about the whole thing. His parents say, why are you all muddy? And he says, oh, Coach so-and-so pulled me over. He's a highway patrolman, and had me do push-ups for speeding. Not allowed. That guy got in big trouble because as a coach, Coach Franklin finds out you got a ticket. He can give you push-ups because he doesn't represent the government. He's your football coach. But when that police officer and that highway patrolman was a highway patrolman, he could not give a physical punishment. That would be considered cruel or unusual. There's no court case. There's no crime you can commit where we go, oh, we're chopping off your finger. Oh, you got to do 1,000 push-ups. That's not how that works. There's no cruel or unusual punishment like that. It's jail. That's what they can do. They can give you jail time. He was not allowed to do that. And so that's a case of like, oh, that's interesting. But ironically, as a football coach, he could do that because as a football coach, he's not the government. He's just a football coach. So coach can have you do that, not a highway patrolman. And that got tricky for that guy because when that highway patrolman pulled that guy over, he was thinking like a coach, and I get it. Powers are reserved to the people. Okay, last two are going to go fast. The Ninth Amendment simply says, essentially, just because a right isn't listed here doesn't mean it doesn't exist. Nowhere in the Constitution does it say you have the right to clap your hands. You do. It's just common sense stuff. The only court case I could think about this one, there was a gentleman who had 7 kids with 6 women, I believe, and he had not kept up on child support. And so the judge said, I'm going to sentence you to either 2 years in jail or for you to have a surgery that would make it so you can't have kids anymore. And he sued. He sued and said, that's a cruel and unusual punishment. One, but it's not, because people do that surgery a lot. But two, even though it doesn't say in the Constitution I have a right to have kids, I have a right to have kids. As long as everybody's willing partners in this, I'm allowed to have as many kids as I want. It's just assumed by the 9th Amendment. It's reserved. It's a catch-all. And the courts agreed. But he still had to go to jail for 2 years for not paying child support. They just took off the option of the surgery. Just because a right's not listed does not mean it doesn't exist. All right, here's your last amendment. 10th Amendment. Powers not specifically given to the federal government fall to the states. That was that thing to make the anti-federalists feel better. You thought the federal government had too much power? Anything we didn't spell out goes to the state. State gets to decide what you need to do to graduate from high school. State gets to decide what you need to do to get your driver's license. Those are things that are not in the Constitution. So the state automatically gets to decide. So my kid's moving to a different state. He has a whole different standard now of what he will do for his driver's license. Now, there's another thing where we recognize licenses in other states and things like that. But as far as like what he has to pay, his license plate, he's got to change them all. It's different state by state. That's all that means. All right. So there's your first 10 amendments. Now, there are 17 more because altogether there are 27 amendments. But these are the first 10. These first 10 all came out in the first Congress, James Madison, and we call them the Bill of Rights because these were the ones that he had promised us when the Anti-Federalists said, where are our rights? So this is the Bill of Rights. Tomorrow, you're going to have a worksheet, and you've got to know these. They're going to give you different scenarios, and they'll say which amendment would be used here, which amendment would be used there. If you've not done it yet, do your document of the week. It is due by the start of class tomorrow, Thursday, because we don't have school on Friday. Okay, so get these easy points. Be ready for this test. Take good notes, and everybody have a great day.